Hello and welcome to Badm 307, The Legal World According to Peter J. Holden. What we're doing in this video is a review session preparing you for your midterm examination. As you know, you've got a copy of that in your materials. It comes in three parts, Part A, Part B, and Part C. Part A are terms that you just match the definition to a term. Part B, there's 5-mark questions and you have to make a selection of those, and you can prepare in advance for some of those if you're following the lecture material. Part C, however, is a problem, and that's how I separate the B's from the A's. In the problem, you are expected to recognize legal issues, which is potentially a problem or an actual problem, and then provide, as well as the issue, the legal principle related to it, which is quite often the definition. So we're going to be going over the tort problem, and that follows very closely with what I've been saying. But before we do that, we're going to get into what we call the law review problem, and this is one that fills in not the contract section or the tort section, but deals with the legal system in Canada and steps in court action and things like that. So turning to the problem, I don't want to bore you, but I am going to read and then stop and talk about issues. So we start off with a mild-mannered accountant, Arnold Abacus, of the firm of Numero Connive, was doing his year-end financial statements for one of his firm's largest clients, the Far, Near, We Ship Beer Here, There, and Everywhere Corp. The beer manufacturer had recently entered into a three-way joint venture with two foreign breweries. However, Abacus was finding a number of what he hoped were innocent errors in the sharing of profits from the partners. When he brought these anomalies to the attention of Barney Belcher, the owner of Far and Near, We Ship Beer Here, There, and Everywhere Corp., it became apparent that the foreign partners were cheating Belcher, and he was understandably upset. Belcher attempted to discuss the problems with his counterparts in the foreign firms, but all he got were obfuscations and delays. So in the end, Belcher asked Abacus to accompany him to the law firm of Bello, Argue, and Harangue. And after a lengthy meeting with litigator Melvin Bello and his very capable junior litigator, Ms. May Sue, a disturbing set of facts began to emerge. Belcher had been so excited by the prospects of soaring foreign beer sales that he had rushed into a business arrangement with his foreign partners without preparation of a formal contract by a lawyer. Instead, all he had were his notes from a number of conference calls and copies of a few letters and emails, which were exchanged between the various players. Abacus provided the financial information and briefly explained the swindle. So in a legal action, Abacus would be called as an expert witness, although that's something that that's totally new. We haven't discussed that before. One of the key things, though, is the next part where it says, in a dejected tone, Belcher asked, "What can I do if I don't even have a contract?" Bello replied, "Oh, you probably got a contract. We just have to figure out what it is. And then we have to figure out what we can do, if anything, about this duplicitous situation." Belcher whipped out his checkbook and gave a sizable retainer and said, "Do what you have to. I don't like getting cheated, and this deal should have been worth millions to me." Now that the retainer goes to what the lawyer, or what you have to pay your lawyer to take legal action, and that's called solicitor and client costs. If you win a court action, then you get the party and party costs, which means a portion of your legal fees will be paid by the other side. Bello ushered Belcher and Abacus out the door and into the elevator, and then said, "We'll be back to you with a legal opinion very quickly. Then we'll have to meet again to decide on a strategy." As the elevator door closed with a ding, Bello turned to Sue and said, "I've got to meet with the 28 people who want to sue the Tons of Tofu restaurant for food poisoning. So you'll do the legal opinion for Belcher. Get the international law specialist that we seconded from our Tokyo office to help you. His name is Sosumi." Now, the 28 people suing, this goes to the legal review of class action lawsuits. They all suffered the same loss, which means health problems because of the poisoning, and they're all looking for the same remedy, which would be damages for their pain and suffering. So that would be really the first issue, the clear issue. All right, going on, Meisu and Susumi reviewed the material and drafted the following letter. And then you're given the letter, and this is kind of interesting because it shows you here limited liability partnership, and then over here it talks about denotes a law corporation, and in the material we talk about a joint venture. So these are goes to the review that we did on types of business organizations. We have corporations. Now, lawyers can incorporate, but we cannot do so to prevent liability. We can only incorporate for tax purposes. However, the corporation, oh gosh, I can't even remember what it is. Far and near, we ship beer here, there, and everywhere Corp. That's a private corporation owned by Belcher, and he uses that to give himself limited liability. The limited liability, you have to remember, stems from two sections in the BC Business Corporations Act, Section 30, which says the corporation is a separate legal entity, and Section 87, which is the one that says that shareholders are not liable for the debts and obligations of the corporation. The limited liability partnership is one of those arrangements where the partners in a law firm or any sort of firm can protect themselves from joint and several liability of the other partners, but they cannot protect themselves against the liability of an associate working for the firm or one of their staff or something that might do something negligent. Then they're all jointly and severally liable for that. All right, so then we get into the discussion of the problem. And this particular problem, I drafted it so that we could use it as a law review at the beginning. And then at the end, when we do international trade law, we can come back to it because it has some international trade law aspects to it, quite a few as a matter of fact. Most importantly, though, on the second page of the letter, the second paragraph starts with, first, do you have a contract? It is generally accepted that there are 6 elements required for a binding contract. Without itemizing them, suffice it to say that the 6 are present. So what you would be expected to in the exam, say binding elements of a contract, and then you would list them: offer, acceptance, consideration, intention to create legal relations, capacity, and legality of object. You should also point out something I'm not sure that we even talked about directly, but contracts, there are 3 forms. There's oral contracts, written contracts, and oral and written contracts. And in this particular situation, Belcher would have a contract, and it would fall into the second category, part oral, and partly written, because he has his discussions with his European and Middle Eastern partners, which is the oral part, but he also has some documentation of that in letters and emails and that sort of thing. So it's partly written, partly oral. A little further down, the information provided by Mr. Abacus demonstrates that Duke Pilsner has, through a numbered company, what's a numbered company? Well, it's just you incorporate a company and you don't want to have a name for it, or you don't know what name you want. You can just use the number that it's incorporated under, BC Ltd, and bingo, you got yourself a numbered company. They were selling Belcher's most popular beer, Belcher Pale Ale, under a confusingly similar label of Bleacher's Pale Ale, and at a price below that of Belcher's brand. What this means is that we have a trademark infringement situation here, and that would there'd be 2 aspects to that, as they go on to mention. The first is that you get to sue them for passing off, which is a common law right. As I was mentioning, you sue them for passing off, which is a common law right. And then you also get to sue them for trademark infringement under the Trademark Act. Common law allows you to sue for damages and get an injunction, but if you sue them under the Trademark Act, then you have far more remedies, and we may be going over that later in the course. All right, then it talks about a private law cause of action. Now, we did review cause of action. There's two things you have to get into court. One is a cause of action, and the other is a recognizable the cause of action is the recognizable legal reason for being there. And the other thing you need is the capacity to do so, and that's standing to sue. Okay? And we talk about conflicts of laws, but that's the second part of the course. Enforcement of foreign judgments, that's in the international section of the course, so we'll get to that later. Then it talks about the Small Claims Court Act, Court and the BC Supreme Court. Now, we did have that diagram of the court system, and that's what that relates to, but on an exam in a problem like this, it isn't something that you would write down. But over the page it says if the defendants fail to appear or defend, Belcher's Beer could make application for a default judgment. We've talked about default judgments. A default judgment is obviously a judgment in the absence of the other side appearing or defending, and it just shortens the legal process substantially. Then that allows the person that has the judgment to levy execution. Levy execution means collecting on your court judgment, and there's 4 things that we can do in order to levy execution. We can garnish wages or bank accounts. We can drag the judgment debtor in on a payment hearing. We can seize and sell assets as long as we get a court order to do so, and we can also register the judgment against land. Okay, then we get into some more we go a little bit farther and we talk about the possibility of going to federal trial court. And the lawyers point out that they do not have standing to sue. They would have a cause of action recognizable in the federal court as far as the trademark infringement goes. But the problem with the contract is that it's a provincial matter under the Section 92 of the Constitution. So that isn't something that you would be able to bring without the permission of the court, so you may not have standing to sue. Remember, cause of action, standing to sue, the 2 things you need. If the defendant has no assets in Canada, meaning the Grand Fenwick and Quagmire, the 2 countries that the defendants are in, if those defendants don't have any assets in Canada, then you wind up getting a judgment in Canada, but it's called a dry judgment. Dry judgment means you win, but there's no assets to go after, and so the well's dry. Okay, the next paragraph talks about choice of law and forum, and those are international trade law concepts that we'll get into at the last part of the new lecture material in our course. But it talks about substantive law and procedural law, and these are terms that you should know for the exam. Substantive law is the laws that you have to follow, the criminal code, no breaching of contract, those sorts of things. Procedural law, though, is the law that I use to enforce my legal rights. So my legal rights stem from substantive law. My way of enforcing it stems from procedural law. Then we get into the last part of this letter, and the meeting after Belcher receives the letter, and it talks about finally Belcher retained the firm to first draft a demand letter, and failing resolution from that to commence legal action against Desert Beer and Duke Pilsner. What we're talking about here with the demand letter is the textbook says that the first official step in a court action is the filing of a notice of claim in small claims court or a notice of civil action in the BC Supreme Court. But in the world according to Peter Holden, the first thing you should do is go to your lawyer, pay a small amount of money to the lawyer, and have the lawyer send a demand letter to the other side. Quite often when the other side, in this case, knows that, we've been caught out here, we really want to pay, but we just can't seem to scrape together the money. Well, the person that screams the loudest will probably receive payment first. It's the old adage, the squeaky wheel gets the grease. So the idea is to send the demand letter in the hopes that that will settle the matter immediately. And failing that, then you can always sue, but if you sue first and then it settles, then you've wasted the money expended on starting the lawsuit. And the last part relates, of course, to alternate dispute resolution, because Belcher says, well, is there just some better way of doing all this? And yes, there is. We will see when we do the international trade law material that the alternate dispute resolution is very valuable internationally, particularly, but it's becoming more and more used domestically as well. And it says the advantages. Well, I think it would be important in a situation like this to list all the advantages, or as many as I asked for on the exam, and the disadvantages of ADR as well. The other thing to remember too is I talked about how a decision in a criminal court is called a verdict, and a decision in a civil court is called a judgment. And what we have here is an award, because the arbitrators are not judges, so they cannot give a judgment. They can only give an award. That award, though, under one of the advantages of ADR, can be converted into a judgment, and you can then begin levying execution. All right, so that was just the introductory material to as a review of the first part of the course. One thing I missed was obviously the European and Middle Eastern partners were trying to defraud Belcher. So the tort issue here would be fraudulent misrepresentation, and the other issue that gets them into court would be the breach of contract. Turning though to the tort problem, this is a little more straightforward and can provide you with a lot more straightforward review. Phyllis Frumstetter, the demo rep for Peak Performance Pontoons Inc., was pumped. After months of demonstrations to river rafting companies, she had finally been asked to go on a 2-day river rafting trip with the Raging River Rafters Co. to provide its customers with an opportunity to try whitewater skiing. She and her assistant, Pitt Quarry, loaded the company river rafting material, 10 pairs of skis, Peak Performance pontoons, poles, helmets, and personal flotation devices into the trailer attached to her company SUV. They then headed off to the Raging River, where they met up with the owner river guide, Donald Duncan. This was at the point of egress. Duncan had 5 rafts of 8 customers each set to go down the river. There were 2 other rafting outlets also preparing to put the rafts in the water at the same entry point, so it was bedlam to say the least. One customer came up to Phyllis and said that she had a coupon for 20% off the rental price. Frumstetter said that they did not give out coupons. And on closer inspection, she noted that the coupon was from a competitor, Pinnacle Performance Pontoons, the maker of an inferior brand of whitewater skis. The customer accused her of trying to get out of honoring the coupon until Phyllis pointed to the other truck with Pinnacle prominently painted on the side. So right off the bat, what's the first issue? Well, the first issue is passing off. Pinnacle Performance Pontoons sounds a lot like Peak Performance Pontoons, and there's obviously confusion in the marketplace because the person with the coupon thought Peak Performance Pontoons was the company offering it. So that would be the kind of evidence that would allow you to sue for passing off. And of course, if Peak Performance Pontoons has registered the trademark, then they could have a double whammy. They could sue for the tort of passing off and sue for trademark infringements under the Trademark Act. There was also a picture of the most famous whitewater rafter of all time, Cyril Soggy. And the caption on the side of the truck said, "Pinnacle is the peak of performance in pontoons." Phyllis was currently dating the famous Soggy and knew for a fact that he thought Pinnacle pontoons were not only inferior but dangerous whitewater skis. Despite numerous offers from Pinnacle, he had refused to sponsor them. Apparently, Pinnacle had their trucks painted with his picture on them in anticipation of him accepting the dollars for the endorsement. When Soggy refused, Pinnacle decided to leave the picture on their vans until they needed repainting or replacing. The issue here, of course, is that Soggy is the only person that can make money off his image or his fame, and so this is misappropriation of personality. That's a common law tort which was started in Ontario with the famous water skier Athens when he won the world championship, and he was going to work for a company and coach, and they were negotiating, and they put his picture on their pamphlets. Then they couldn't make a deal, and he left, and they thought, oh well, it's just a picture of him. They used it anyway, and it was 1972, and the court in Ontario created the tort of misappropriation of personality. In British Columbia, we have a double whammy. We get to sue him under the common law tort of misappropriation of personality, but also our Privacy Act says that it's actionable without damages if someone uses your picture or likeness to make money. All right, so that was the second issue. The third one comes up in the next little bit of this paragraph at the top of page 69. Duncan came over to Pitt with one of his customers who was interested in trying to whitewater ski, but the customer looked at the brand name on the ski and said, "Oh, I don't think I want to go after all." When Corey asked him what was wrong, the customer told him that the demo rep for Pinnacle had said that the peak performance pontoons often failed and the users were dragged a long way underwater before the bindings actually released. This was totally untrue, but despite Pitt's effort, the customer could not be convinced otherwise. What issue is this? Product defamation. Okay, the tort of product defamation, which is injurious falsehood in old English language, law language, but product defamation is sufficient. Making an untrue comment about someone else's product or service is the same thing as defaming, but because you're not defaming a person, this is the specific tort that you have to rely on. However, Duncan managed to line up 10 other customers who were eager to give the new sport a try. Phyllis and Pitt handed out the skis, poles, helmets, and jackets, all the while explaining the proper adjustment of the ski bindings and how to properly wear the helmet and life jackets. They also explained the basics of getting up on the skis and what to do if they fell, carefully outlining the risks associated with the sport before asking each participant to read and sign a waiver. Now, I guess the issue here is, and I hadn't thought about this one until right now, but the issue here is that if you have people at the side of the river and they're about to go down the river and you ask them to sign a waiver, that waiver may not be enforceable because they really didn't have time to consider it or consult legal counsel if necessary. What might save peak performance pontoons here is that getting down the river is something that they've already paid for with the river rafting company, and so this is incidental. And so if they said, hey, listen, I don't want to sign the waiver, then they have some way of getting down the river without a problem. Okay, then the next paragraph, this is just fun, and here you get to hear your instructor sing. That was when the Pinnacle group began to chant and do a little line dance. Look at the peak pontoon, wimps standing on skis the size of blimps, guides doing all the boat talk, but can they do the float walk? What are the forms for? Forms are such a bore. Pinnacle skiers are the tops. For us, there are no stops. However, the Peak Performance Group had the next laugh. Apparently, Thornton Thick, the driver of the Pinnacle van, forgot to put the emergency brake on, and the van, for some reason, began to roll down the slope towards the river. All Perry Pinnacle could do was stand there with a stunned look on his face as his customers began jumping out of the way. The truck would have gone right into the river had it not struck one of the rafts, sending one of the guides and 2 bags of gear on an unplanned float down the river. The guide was able to swim to the shore, but the 2 bags of gear were sucked into the rapids and lost. The hitch on the van punctured the raft, and everyone watched silently while it rapidly deflated along with the Pinnacle group's egos. I should write novels. Well, obviously, forgetting to put the brake, negligence. To be successful in suing someone for negligence, you have to, the plaintiff has to prove that the defendant owed a duty of care, the defendant breached the duty of care, and the defendant caused the damage, all clearly present in this particular case. So the person that forgot to put the brake on the van it was negligent. But what about Pinnacle Performance Pontoons Inc.? Well, they are vicariously liable. So don't forget that tort. It's not a tort, pardon me. Don't forget that issue. Okay, there's torts and then there's vicarious liability. Vicarious liability is not a tort in that for vicarious liability to apply, there has to have been a tort committed. But once the tort has been committed, then the employer becomes responsible for the damages caused by their employee committing the tort during the course of employment. Okay, so over the page, Pitt walked over to Thornton Thick and in a loud voice said, "After I finish my safety talk, I'll come over and instruct you on how to properly use the emergency brake." An incensed Thick took a swing at Quarry, who stepped out of the way, grabbed Thornton's arm, and sent him headfirst into the water. Mildred Meek, a generally mild-mannered lady, came at Pitt with a ski pole and told him to back away. However, before anything else could happen, the owners of the two groups, Duncan and Pinnacle, came by and got everyone to calm down. So the issues here, well, the swing at Pitt by Thick is an assault. The principle for that would be the apprehension of imminent harmful or distasteful contact. And then, of course, Quarry gives him the old grab on the arm into the water. What you've got here is battery, the merest unconsented to intentional touching of another. But you could say that Pitt had a defense, and that is self-defense. He used no more force than was reasonably necessary to prevent a battery. Now the Mildred Meek coming at Pitt with an oar, with a ski pole. This is obviously an assault, and because Pitt expected to be hit. However, she might have a defense in the sense that she might be able to claim defense of a third party. She was coming to help Thornton Thick. Okay. You don't think it's an issue? Put it down anyway. Okay? Because I might think it's an issue. And if you put down defense of a third party, and I said, no, I don't think it is, I will not take any marks off. But if you don't put it down, and I thought it was, then you're missing some marks. The only time you would lose a mark is if you put down, that had to be, I don't know, defamation or something completely wrong, okay? Then I might say, this person is demonstrating an inability to grasp the course material, but usually I don't do that, okay? So if you think it's an issue, put it down. The guides of the various rafting companies began to launch their rafts amid great excitement, and the anticipation was once again but once again, the Pinnacle group were experiencing difficulties. At the last minute, those in the Pinnacle rafts were also asked to sign waiver forms. Oh, here's what I'm getting at. The standard form contracts, okay? Peak Performance Pontoons did it properly. They gave people ample opportunity to read the waiver, sign the waiver. Okay, but just before the people are getting into the Pinnacle Performance rafts, they say, oh, but wait, we forgot, sign here, sign here. Well, no one has an opportunity to say, hey, wait, I don't like that. All right, so right at the last moment, they had to sign the forms. When Mildred Meek and the others asked what they were, Thick said, no big deal. You're just acknowledging that there are some dangers associated with the sport. Let's get them signed and get underway. We don't want to be last. Well, that's shooting yourself in the foot because it is a big deal. There are dangers. You have to make them aware of the dangers and make it clear that they're waiving their legal rights. So even if people had signed those forms, the fact that they're at the last minute and the no big deal means that that they probably would not be enforceable in court. Okay, so standard form contracts, the principle here is what was done at the time the contract came into existence to bring an onerous term or condition to the attention of the contracting party. What was done here? Absolutely nothing. In fact, the reverse was done. Instead of telling them about the onerous term, that you're waiving your legal rights, they said something to the contrary. Okay. After coming to the defense of Thick, Meek apparently had second thoughts about whitewater rafting, let alone the wisdom of whitewater skiing. She whimpered and said she did not want to get, she wanted to get out of the raft. However, Perry Pinnacle, the company owner, did not want to be last leaving after the embarrassment of the truck on the riverbank. So he bellowed, "Lady, it's too late. Sit down and shut up." A terrified Mildred sat on the bottom of the raft, and her eyes screwed shut, and she held onto the safety line with a vice-like grip for the whole journey down the river. This would amount to the tort of false imprisonment, intentionally and without lawful justification subjecting another person to the total restraint of movement, or by actively preventing them from leaving the place in which he or she is. Okay, so yelling at somebody to sit down, obviously they were terrified, so that would amount to false imprisonment. On a calm section of the river, peak performance skiers took to the water and practiced getting up on their skis and practiced recovering from a fall. The Pinnacle group, on the other hand, laughed and jeered. Later, however, as the skiers entered the whitewater, the peak performance skiers acquitted themselves well, while the Pinnacle group could be seen dropping like flies with skis and poles flying through the air. As the Pinnacle's guides went about the task of rescuing the skiers from the water, one guide, Reggie Ruff, decided to save his rescue throw line and instead used one of the extra ski poles to pull a skier into the boat. However, in doing so, he gave one skier who had lost his helmet a nasty whack on the head and gave another one a pierced ear. I can't help it. Anyway, in the Tourism 208 course that I was teaching, we talked about negligent rescue, and this is one of them. For us, it's just negligence, pure and simple. And not only would the guide be liable, but Perry's company and Perry, if it's incorporated, or Perry personally, will be vicariously liable. So again, it's negligence and vicarious liability. Fortunately, there were no fatalities. However, 2 of the skiers had to be rescued by peak performance guides and were sent to the hospital suffering from hypothermia and shock and mental distress. By the time the remaining skiers were rescued by Pinnacle Performance guides, it was too late to reach the point of the river where the rafters were entitled to camp overnight. Instead, they found an accessible spot on the bank of the river and proceeded to make camp. Despite foraging for wood and building campfires, the rafters spent a rather miserable night with little sleep. In a hurry to get away the next morning, they tossed their garbage into the bushes and walked away from the smoldering campfires. Now, going onto somebody else's property like that, uninvited, is obviously the tort of trespass. Okay, someone who comes onto property unlawfully. And tossing the garbage down is the tort of private nuisance. The owner of the property, Barnaby Bushman, came down the river bank to investigate the smoke he saw from his cabin. When he saw what the rafters were doing, he began to yell at them. The rafters quickly hopped into their rafts and used their paddles to push off. Bushman might have been able to grab a couple of them, but he had to stop and put out a small fire that had spread from one of the campfires to some nearby bushes. As the rafters floated out of the sight, jeering and giving him the one-fingered salute, Barnaby picked up an equipment bag left behind in their hurried departure. On the side of it it read, "Return to Pinnacle Performance Pontoons, Inc., followed by an address. Bushman walked back to his cabin, whistling the tune to Finders Keepers, Losers Weepers, and thinking to himself, whatever is in the bag will help cover the cost of the damage to my property, and the name on the bag tells me who those creeps are so that I can sue them. After the river rafting, let's see, okay, let's stop there and go back and look at the issue. Finding the bag is the whole concept of bailment, which we did not do in the review, but which you will be required for this exam just because we're dealing with it now. Bailment is when the bailor leaves goods with a bailee for the purposes of either transferring title or having him dispose of it in accordance with his wishes, or returning it after his use. That's the concept of bailment. In this particular situation, if you become an inadvertent bailee, i.e. somebody leaves something on your property, it does not give you the right to keep that. So finders, keepers, losers, weepers is not a legal term. And this person would have to, Barnaby Bushman would have to compensate them for using those goods, because to do so would be the tort of conversion. Okay, so here we have bailment situation. It's called the law of finders. He has more right to it than anyone else in the whole world except the owner, and has to make reasonable efforts to return it. So he should get it back to them. He still has the right to sue them, of course, for trespass and private nuisance. But taking it and saying, well, I'm going to compensate myself with it, means they're converting someone else's goods to one's own use. Okay, pushing on, we're almost done here. After the river rafting and the water skiing and whitewater skiing adventure, Phyllis Frumstead returned to Peak Performance office and dumped her skis, poles, and helmets on the floor of the store. She reported to the owner, Arnold Abacus, that the Peak Performance pontoons had worked out perfectly, and most of the skiers not only enjoyed themselves, but some of them wanted to buy their own skis. Phyllis then recounted the antics of the owner and staff of Pinnacle Performance pontoons. While Arnold was laughing, a thief in the store grabbed a pair of pontoon skis and raced for the exit. However, the automatic glass door failed to function, and the thief collided with it, knocking himself out. The crash startled a customer who tried to back away and fell over Frumsteader's skis and looked dismayed as a rack of skis fell on top of her. She was badly injured and had to be taken to the hospital along with the thief. As the two were carried out the door on stretchers, Abacus was heard to say, "That darn door has been a problem for months. I've got to get it fixed one of these days." Now that comment has got to be important. Okay, so what's up here? Well, obviously the thief is on the property illegally. All right, so it's a trespass. Grabbing the skis and running for the door is the tort of conversion. Conversion can be a theft, or it can be taking something under color of right. Theft is when you grab it and you run out the door because you know you want to keep it. You have the actus reus, the guilty act, and you have the mens rea, the guilty mind. So it's a crime. But if I picked up one of your textbooks and thought it was mine and walked out the door, I have converted your goods to my own use, so that's a conversion, but it's not theft. Okay, so the difference is I did the actus reus. I took something that didn't belong to me, but I didn't have the mens rea. I didn't have the guilty intent to do so. So remember that when you're dealing with conversion. Don't say, oh, the issue is theft. It's the tort of theft, because there is no tort of theft. Thievery is a crime, but conversion covers both. Okay, conversion covers the taking of goods intentionally or under color of right, meaning you think it's your own. All right, so that's trespass and conversion. Now the customer backs away and falls over the gear on the floor and is badly injured. This is the tort of occupier's liability. To get full marks here, you would say occupier's liability, the person that fell was an invitee, okay? And then you would say that the owner has a duty to remove dangers of which they are or ought to be aware. the occupier's liability. Somebody comes onto your property, they can come on in 3 categories. We got 2 of them right here. We got the trespasser, and we've got the invitee. Another person would be someone who came over to visit Arnold because they were good friends. Oh, Arnold, I haven't seen you for a long time. Well, they're actually a licensee. They have an implied license to come onto the property. So the thief was injured, and you would think in most normal circumstances that there was no liability to Arnold Abacus or Peak Performance Pontoons Inc. But in fact there is, because when we look at the duty that you have to show towards to people that come onto the property when you're an occupier, for a trespasser you cannot injure them through careless disregard. And that's the last line. Okay. That darn door has been a problem for months. I've got to get it fixed one of these days. What that means is that he was reckless and caused injury to a trespasser. So the thief will be arrested, charged with the crime of attempted theft, but Arnold Abacus might find out that he's been sued. All right, so those are the torts in the problem. Oh, I'm sorry. Gosh, there's another page. It just goes on and on and on, doesn't it? So let's just deal with that. By the time Perry Pinnacle got back to his office, there were so many process servers trying to serve him with writs of summons and notice of claims. This is a little out of date because it was drafted, let's see, 2 years ago. And just last year we changed our process so that we have no longer writs of summons, we have notice of civil claim. However, it just deals with the someone trying to sue. At the end of the day, he gathered up the forms and went to visit his lawyer, Kyle Costley. Costley reviewed the forms and then asked Perry to wait while he made a quick call to his wife. On the phone, he quietly said, "Honey, book the European cruise. Trust me, we can afford to go after all." Beads of sweat broke out on Perry's forehead as he asked how much the legal fees were going to be. When Costley told him how costly it would be, Pinnacle, whose business was already in financial difficulty, knew he could not afford to defend the matter, but he said, "No problem, Kevin. Just bill my company." He was almost hyperventilating as he waddled out of the office. But Perry comforted himself by thinking, if worst comes to worst, the Pinnacle Performance Pontoon Company cannot pay the bill, but at least that's a company debt, and I won't be personally liable. All right, so what's the issue here? It relates to the concept of the corporation as a separate legal entity. The contract between Kyle Costley and the corporation is a corporate debt. The corporation can't pay. Usually, that would mean that the owners of the company, the directors and officers, or the shareholders would not have to compensate them. However, one of the ways that the corporate veil may be pierced to make either the shareholders, directors, or officers liable is fraud. And when Perry Pinnacle said, "Don't worry, just bill my company," when he knew the company was already all but insolvent, meant that he was perpetrating a fraud. And so the corporate veil can be pierced and he can be held liable. All right. Now, once you've gone through those and found out what you got and what you missed, if you have any questions, then in the next class we'll be able to handle those very quickly, and we've saved some time. We'll do more of these for the review as things go along, but for the time being, that's it. Thank you very much.